Mr. Vice Chairman, Sir, I would like to make a mention of some of the problems of the workers in general and those of the scheduled castes and scheduled tribes in particular. Sir, in the first place, I would like to state that the railway administration does not provide to the workers a speedy and efficacious remedy against their grievances. If a worker is demoted, he has to go to the High Court after appealing to the executive authority. If a worker is superseded, he has to go to the executive authority in appeal and then to the High Court. If he is removed or suspended from service, he has first to go to the executive authority and ultimately a right is administered to him to go to the High Court. The result is that if a worker is dismissed from service, even though his dismissal is not proper or wrongful, he will not get the relief unless he goes through this channel of appealing to the zonal authority, then to the labor board, and ultimately referring the matter to the High Court and lastly the Supreme Court. The result is that in a case where the judicial authority holds the termination illegal and improper, the railway authorities are required to pay back the entire wages. It is all right that we have removed and dismissed a large number of workers. I think they are in thousands. What is the outcome of this? The outcome would be that there will be a large number of cases in the High Courts and the Supreme Court. Ultimately, it would be seen that even if 1/4 of the workers get the relief of reinstatement and back wages, the railway administration will be required to pay to the tune of crores of rupees by way of back wages, and therefore the time has come when we have to consider afresh as to how our industrial relations should be. Sir, my friend has very rightly pointed out that under the industrial law, a worker can certainly, after dismissal, go to the court immediately and get his case adjudicated. That forum is available and that remedy is available. But that is not so in the railways. And I cannot understand what difficulty there could be if you provided a forum for speedy and efficacious remedy. Then the worker will also understand that his case is being judiciously scrutinized and he will feel that he has no case and he will not proceed ahead. But when he spends 1 year or 2 years before the adjudicating authority, he knows, and the Honorable Minister would also agree with me, that by and large the tendency is to uphold the order of the lower authorities, howsoever wrong, illegal, improper and malified that order may be. That is the tendency, and ultimately when a judicial scrutiny is held, that order is set aside and the result is colossal loss which the railways are called upon to bear on account of their wrong policies. Therefore, my suggestion would be that it is high time to consider that the railway administration gave every worker a forum where he can seek the redress of his grievances without much time being consumed in between, and in that way it will be beneficial both to the workers and to the railway administration, and therefore this should be done. This is one of my suggestions. Secondly, sir, even though the railway administration has now taken a decision that all those who had participated in the strike but were not responsible for any sort of violent activities or sabotage or intimidation should be taken back in employment, I can say, without being contradicted, now that there are today hundreds of workers who have been removed from work and there is no charge against them, and that they have not done anything that would amount to intimidation or anything that would amount to doing something violent or involving violent action, but still they have not been taken in employment. I have myself represented some of the cases. I cannot understand why they have not been taken in employment, and therefore in all such cases there has been inordinate delay in taking them back. The Railway Board should now examine and find out who is responsible for the delay in the disposal of these cases. That is the responsibility of the Railway Board and of the general managers or the zonal managers or the divisional managers, whosoever were entrusted with the work of supervising the cases and taking appropriate action, and if they have committed lapses, they should be dealt with so that such a delay on the part of the railway administration would not be repeated. Then I may point out that in respect of the scheduled castes, there has been discrimination. If an inquiry is held, it would be seen that the scheduled caste employees have been discriminated against. They were removed from service though they did not participate in the strike or any violent activities. Now, sir, honorable members will recall that the bill was introduced in the House of the People on the 2nd September 2003. It has had a long history, and in one form or another it has been before the public since the end of 1949. In the statement of objects and reasons, the various stages through which the bill has passed since 1946 have been summarized, and I need not recapitulate on this occasion the circumstances in which the then Government of India took the decision in early 1946 to initiate an inquiry into the reform of our company law. I would remind honorable members that between 1946 and 1948, the entire field of company law was carefully reviewed by two distinguished company lawyers who were appointed to recommend the broad lines on which the present act should be revised. Their recommendations were examined in the then Ministry of Commerce, and certain tentative departmental views which emerged were circulated in a comprehensive memorandum to all recognized trade and industrial associations, bar associations, the high courts and the state governments, that brought us to the end of 1949. Many representations on this memorandum were duly received from chambers of commerce, trade and industrial associations, state governments and the general public. 1000 प्लस वर्ड है और ये आपको SSC C D ग्रेड टेस्ट के नाम से मिल जाएगा. टेस्ट नंबर 100 है. 80 पे लिखेंगे. Ready? Started. Madam, Vice Chairman, the question of deficit financing has been raised in this House on several occasions. I am no financial or economic expert, but whatever common sense that I possess guides me in one direction, and it is this, that it would be unscientific and uneconomic to put a ceiling on deficit financing as such. I do not see any sanctity attached to a ceiling to be fixed, because if the production increases in the agricultural sector as well as in the industrial sector, there is no harm if deficit financing is resorted to. But if there is a shortfall in industrial and or agricultural production, and even then if purchasing power is pumped into the system, it may be that inflationary pressures might arise. But our past experience shows that even if we accept the various estimates that we made regarding the volume of deficit financing till today, which might have amounted to rupees 900 crores or more, in spite of a volume of expenditure of that nature, we do not see those pressures which can be called as alarming. In a developing economy, some rise in prices is going to be inevitable, because whatever you might plan to spend may not produce immediate economic results. A project might take time to give you dividends. In that process, it is possible that for a certain period of time, there might be rise in prices. Our experience shows that the volume of deficit financing that was resorted to in the past has been absorbed in the economy, and if we step up our effort and increase production in the future, I do not see any necessity to put a ceiling on deficit financing as such. Now, the resources which are required for running the administration have to be raised by the state in one or two ways. One of the ways is that the money which is required for current expenditure may be raised by taxation. The money which is needed for purposes of capital expenditure may be raised by borrowing. But if both these sources do not give us sufficient money to implement our program, then the government has no alternative but to resort to deficit financing. I would therefore suggest that efforts should be made to mobilize the savings of the people for development. I have been saying that there is surplus purchasing power in the rural areas. As you are aware, 70% of the population of the country reside in villages. The biggest industry that we have got is agriculture, and nobody can deny the fact that the return for agricultural produce has certainly increased, which has resulted in an increased purchasing power in the rural areas, and which is now being spent on higher consumption. It is for the purpose of retaining consumption of food grains that I am suggesting that we must make every effort to remove that surplus purchasing power for the benefit of society as a whole. We may get marked loans to the extent that we desire, but our only hope of increasing the rate of development in this country lies in our success of small savings, because unless we intensify our efforts in mobilizing the resources lying in the rural sector, that saving is likely to be dissipated. I would therefore urge upon the Finance Minister to intensify his efforts and step up our target for small savings. Now, I will come to the question of taxation. The Finance Minister has made proposals for raising a further revenue of rupees 23 crores only. Even though on current account there is a deficit of rupees 82 crores, he has not thought it wise to raise the entire amount by taxation. In that direction, he has adopted the wisest course, because the level of taxation that we have now reached is of such a nature that it may be that further rising of resources by taxation may hamper production, because the task of the Finance Minister is to evolve such a system of taxation that it does not hamper production, but in a way proves as an incentive. Now, for that purpose, let me take the case regarding his proposals for direct taxation. I will make a reference to the taxation on companies. The Finance Minister has been assailed on both sides. Neither my friends sitting opposite nor the Federation of Indian Chambers of Commerce and Industry are satisfied. This very fact shows that the proposal of the Finance Minister is in the right direction. Those friends who oppose the withdrawal of the wealth tax on companies did not care to study the speech of the finance minister. If they had devoted certain time and attention and had the patience, they would have found in the budget speech itself that what he proposed was only absorbing the wealth tax on companies and the tax on excess dividend in his new proposals of taxing the companies. A great furor has been raised regarding doing away with the grossing of dividends. ये 80 की स्पीड के साथ डिक्टेट किया गया है और ये भी आपको SSC C D टेस्ट नंबर 100@80 के नाम से मिल जाएगा। अगर आपको 9 वाली फाइल में टाइप करना है तो ये 459 नंबर है।